mock trial folks I see on here. Is that right, Wes?
I think there are maybe a couple 1Ls. I know there are some 2Ls here, and I think there's me, the 1 3L. So
Okay.
Camacho is also he's a 3L. So we are the lone ones.
Okay. So this is, I guess, a workshop that you all are going to do. What? Give them like a little simple fact pattern, little basic fact pattern. Then they're going to practice the summation Thursday.
Yes, we will. If you definitely want to join for that, just to see what we got,
Yeah.
greatly appreciate it.
If I can, I will. What's the fact pattern about generally?
Well, I made it last time, and there was some. I kind of made it on the fly, so there was also obviously some kind of things that were missing, but it was a criminal fact pattern. Um, I was thinking about maybe using the same, just like adding a lot more to it and actually making it a little more detailed. So that way, so we don't have uh, you know issues with it. But probably going to be the same one as before.
Okay. Well, let me again, y'all chime in. Anyone on this Zoom, I don't know how long this goes, but y'all are welcome to ask questions at any point, or in general. I like to be a resource to anyone at LMU for the purposes of any type of question, whether it's what am I doing with my life? This is miserable, or what kind of law do I like to practice? What do you not like about practicing law? Anything, right? Because I'll tell you all, I didn't have any lawyers in my family. And so I didn't have really anybody to ask these questions. And I found myself somewhat at a disadvantage compared to some of my colleagues whose dads were lawyers and moms were lawyers and brothers were lawyers. And they really seemed to really know what they were doing, right, in law school. And I was just kind of figuring it out, just realizing that it was not fun, except for like bar reviews where we go to the bars, or the fun law proms and the general law school drama. That was always entertaining to me. But overall, I would love to help you all in any way I can. Okay, so that being said, summation, right? Your closing argument. I'm assuming some of y'all understand how the process works, but just to be, we'll go over it real quick, right? You're in a real trial. We're talking about, this isn't mock trial world. What I'm talking about is real world trial advocacy. And there's a difference in mock trial and real world. Well, obviously, one being it's a much shorter event. Start to finish is 3 hours. I've tried a case for 2 weeks. All right. So sometimes when you're starting your case and ending your case, you've got a lot of stuff to cover in between. But I'll talk about this being in the context of a jury trial, which is a lot different than a bench trial. And just to be clear on that, a bench trial would be, it's just you and the judge. And I have had judges tell me they don't want to hear an opening. They don't care. They don't, because opening's not evidence. Well, neither is closing. Whatever the lawyer's saying during the closing argument under the rules is not evidence. And what that means is what I'm telling you should be a summation or my interpretation or my persuasion of what the evidence is. So the stuff that's in the trial, the stuff that's come in, the testimony of the witnesses, the exhibits that have been introduced, that's the evidence. What the lawyers say is not evidence, and that goes for openings, cross-examinations. Now, that being said, we all know that jurors are going to listen to what the lawyers say, right? So there's still, you have to be credible in what you say. But technically, what you're saying is not something that the jury should make their decision on. They're making their decision on the evidence. What you're doing is telling them why it's in your favor, all right? So to start a trial, you have what's called a voir dire, or as these fancy lawyers want to call it, voir dire, right? Voir dire. It's the thing that the juries never see on TV. It is the only opportunity ever that you'll get to talk to the jury. It's amazingly powerful and nerve-wracking and scary. You get up, I'll tell you this, most jurors don't want to be there. If a juror wants to be there, you got to be careful because they're really there for a reason. So most people do not want to be on jury duty. It is a big, smelly room of people that you're like, who are these people? It is a week to 2 weeks. You get called every day and you got to take off from whatever you're doing to go down there and listen to some lawsuit. And if it's a dog bite case, they are not real interested in it. All right. In a criminal trial, it's going to be a little different. The juries are going to be a little more entertained by being there. They're also going to automatically, the studies show, they're automatically going to think if you're sitting there as a defendant, you did something wrong. So there's inherent bias there. And similarly, from the plaintiff side, if you are trying a case like a slip and fall and your client's sitting over there, they're going to think they're just in it for the money, right? So you're automatically dealing with this inherent bias. People always talk about the McDonald's coffee case. Well, I mean, that's the quintessential, this woman spilled coffee and got $2 million or whatever. Well, there's an amazingly good documentary on that case, and it talks about how the facts of that case are completely different than what actually happened. If you don't know what I'm talking about, you should look it up because I use that in my board diary, right? I say, you probably think, McDonald's coffee cup, turn a wreck into a check. Has anybody ever seen this documentary, right? And I go through it. And by the end of it, I've hopefully explained why what they got was not worth nearly as much as the injury she sustained. She got like 1 day's worth of coffee sales, basically. Anyway, we're not here on board diary. So you start at board diary and you go to your opening statement. Opening statement, you're basically laying out the roadmap. This is what this case is about. This is who you're going to hear from. These are the witnesses. These are the exhibits. This is our theory of the case. Biggest part of these things is you got to have a theory of the case. That's as simple as, what am I going to tell someone if I was sitting at a coffee shop and they asked, what's your case about? How would I explain it to them very quickly, right? My theory of the case is, this is a case about a company who doesn't care about its customers, who leaves substances all over the floor. And my lady was just one of the unfortunate people who stepped in it, right? That's the case about, whatever. Then you go through. Plaintiff goes first in Tennessee. Plaintiff puts on their proof. They put on their witnesses. And then the defense goes. Defense puts on their witnesses. And then we come to the summation. Do not think that the summation is where you win your lawsuit. All right. It's not the time in which you're going to convince these people, this is why I'm right. Studies have shown, multiple studies have shown, most jurors have made up their mind by voir dire before they've heard any actual proof, because people have a tendency to want to pick a side. It's just this weird feeling, right? You've probably already thought, I like this guy or do not like this guy. It's just a natural thing. So closing is really the opportunity for you to tell them what's important for the 1 or 2 people who are really that take charge. And what I mean by that is, in Tennessee, you have a jury of 12. Of those 12 people, you're probably going to have 8 or 9 that are going to be fairly passive. And you're going to have 1, 2, 3 people that are going to be much more assertive. And those 1 or 2 people in Tennessee, you have to have a unanimous verdict. So all 12 have to agree, not only on who wins, but on how much, or obviously if you lose, you're not talking about money. All 12. So what ends up happening is, and I had this happen one time, I tried a federal jury trial for 3 days. The jury was out for 2.5 days. Random thing. I told you, you only talk to these jurors during voir dire. In federal court, you can't even call them by name. You've got to call them by number, okay? Their jurors are very protected. So randomly, I'm downtown one night with my wife, and I see this see this lady, and I know her immediately because I tried a case in front of her for 3 days, 2 years ago, from the time that I met her at the downtown. And she just walks right up to me and just says, "Hey, I have to tell you this. I believed you. I was on board, but they made me go that way," right? So she was one of those passive people, and there was a person in there who basically said for 2.5 days, "We're not leaving this room if the plaintiff wins." So what are you doing here? You're given in summation what are the really crucial pieces of your case that hopefully the people that are going to be swaying the other jurors are going to use to convince those people that are not on your side. So the first thing you're going to do is you're going to reiterate your theory of the case. So you might have heard the term bookmarking, right? This case is about X. That's the first thing you're going to come out. And it's the same thing that you're going to say in your opening statement. This case is about this. And you're going to end your opening with this case is about this. And when you finally come up again, whether it be 2 hours later or 2 weeks later, you're going to remind them, this case is about this. It's what I told you when we first got out there. This case is about whatever your theory is. All right. It needs to be super simple, and it doesn't need to be, technical. And what I mean by technical is you're not using words like negligent, strict liability, respondeat superior. You're talking about irresponsible. This person controlled the other. She worked for them. You got to hold people accountable when they make products that are used by everyday folks. You know what I'm talking about, right? You're simplifying the theory, and you're telling them basically what I told you at the beginning of this case. You have now seen it come true. And you find me and what I've told you throughout this trial to be credible, right? You don't want to lose any of the credibility. So number two, you want to emphasize, obviously, your favorable evidence. What you want to be very careful of, which happens all the time in the mock trial world, but even in the real world, is you don't want to talk about evidence that did not actually come into the trial. So for example, if you have, let's say it's a car wreck case and the defendant had a DUI, and you ask the defendant on the stand whether or not he had a DUI. The other side objects. The judge calls you up there and he says, "What are you doing?" And you say, "I don't know. I'm trying to get this DUI in." He's like, "Ain't coming in, counsel. Move on." All right. And then you go to close and you say, this person did all this stuff. He had a DUI. Boom. Totally, you've ruined it. Your whole closing is probably potentially a mistrial, depending on how damning the evidence is. So, two, emphasize your favorable evidence, but make sure it's actually in evidence, right? So you all, I don't know, you may not know what in evidence means, but the point is, in evidence is evidence that has been elicited through either exhibits that have been introduced or testimony on direct or cross-examination. It is not what you say, right? So emphasizing your evidence. Closing in Tennessee, again, it's different in other states, but in Tennessee, plaintiff goes first, defense goes next, then plaintiff gets to rebut. So there's a lot of strategy involved. When you're the defense, you've heard what the plaintiff says in their summation, their closing. You probably need to rebut some of that stuff. You probably need to talk about some of the stuff that they said and either spin it your way or talk about why it really isn't relevant, or what you would say a red herring, right? It's not, this isn't, they're sending you on the wrong track. Let's get you back on the right track. So you have the ability to rebut. And then the plaintiff, you all probably aren't going to be doing this in your thing on Thursday, but in a mock trial and in a real world, you're going to get to rebut. And that's just the greatest part, because that's literally, you got to go first and say all the stuff that was kind of, you know, everybody expected you to say. The defense goes, and now you get to stand up and say all kinds of stuff the defense can never rebut again. So it's like, now let me tell you the real story, right? It's like, I've seen plaintiff's lawyers stand up and say, I'll be back in a minute, and then just sit right back down. Now, is that a great idea? I don't know, but you have that ability because you can rebut in Tennessee. In some states, defense goes first. It's crazy. All right, so you want to rebut your opponent's allegations. What I think to be one of the most impactful, again, probably not going to win or lose your case. Well, you could definitely lose it, I guess, but you're probably not going to win your case. But to the extent that there are some people on the fence, then people have a tendency to believe the written word. So in other words, if I were to show you something, you're going to believe that over what I'm telling you, because people just believe what they see. It's not the picture's worth 1,000 words. It's people believe the written word. So you see this thing. So again, maybe not for your thing on Thursday, but most summations are going to be a PowerPoint type summation. And those PowerPoints are going to use words that are anchored words. So at the beginning of your trial, let's say it's a car wreck, you would say there was a car wreck between these two vehicles. In your summation, it might be the catastrophic collision, right? The words are different. Car wreck, catastrophic collision, soft tissue injury, or a crick in their neck for the rest of their life. You're going to probably present that in some PowerPoint form, and it is an amazing tool for you as the advocate, because it actually kind of works as a cheat sheet, because you're kind of, you hit that thing and you're like, oh yeah, I need to talk about that. You're like, because you're not memorizing a huge close, you just can't. So it almost is a guide for you to kind of keep yourself on track. So you make sure you've hit all the points you want to hit. So people believe the written word. The other thing that I find to be very impactful, and let's see if I can just do it real quick. If I had Sarah here, she could just pull it right up probably here. Well, I just, doesn't matter. Just making this stuff up as we go, right, folks? Hey, let me share, Wes.
Hey, give me a second. Let me.
I'm really not making this up, by the way, I guess.
You
don't know me well enough to know that I kind of am sarcastic sometimes.
How do I let you share? I guess. There you go.
Oh, there we go. I'm in.
Cool.
All right. Can everybody see that?
All right.
All right. So this is that trial that we just tried in our mock trial class. Right. So now, does this not automatically make your attention better? Again, I can't see anybody, but to the extent that you're nodding, I feel good. You're seeing this, right? You're like, oh, yeah, right. You're believing the written word. But what I was going to say is you want to use your jury instructions. This is the ultimate part of the trial. When you try a lawsuit, what ends up happening is the judge, either after you close, or if you're lucky, before you close, is going to read the jury instructions. It is the worst part of the trial, meaning it takes like anywhere from 45 minutes to an hour and 45 minutes. And the judge literally just reads line by line, 25 pages of instructions, and it is miserable, all right? But those instructions are what the jury's supposed to go back and deliberate on. It tells you what's negligence. What do I do about conflicting testimony? How do I evaluate the credibility of a witness? How do I come up with a damage amount, right? Those are all going to be part of your instructions. And at the end, the jury is going to actually have a verdict form. And this is what it's going to look like, this verdict sheet. So in my close, you would want to use the verdict sheet and say, ultimately, ladies and gentlemen, this is what you're going to have. You're going to have a verdict sheet. And this is all you're going to be answering today, these questions. And I'm going to tell you why you answer them the way we say you should, right? Question 1, was he negligent? Absolutely, right? You'd like check it. Again, people believe the written word. So, all right. And you're telling them again why. All right, hold on, I lost my place here. Here we go. You're using that verdict form to suggest the outcome to them. Does that make sense? Because you're basically, the whole trial comes down to their decision. And if it's a criminal trial, you're going to have a verdict form like, you know, did the defendant commit an assault on the victim? You know, do you find by beyond a reasonable doubt? And so in a closing for a criminal trial, the prosecutor, meaning the one that's going after the defendant, they're probably going to be harping on that beyond a reasonable doubt. Excuse me, the defense that's defending is probably going to be harping on that beyond a reasonable doubt, saying that's a really high burden to meet. And so from a defense standpoint in your close, as part of your persuasion and telling them, suggesting them why they're going to resolve this in your favor, you're going to say, listen, folks, there's a lot of doubt about this thing. Let's talk about what those doubts are. Well, nobody saw this guy at the scene. I mean, we've heard people, but their whole case is based on what's called circumstantial evidence. If y'all don't know what circumstantial evidence is, it's a great example is this. Somebody comes into your apartment and they've got an umbrella and they've got a raincoat on and it's wet and their shoes are wet and their umbrella's dripping. You probably have a good basis for thinking that it's raining outside, but you never saw it rain. You haven't looked outside, right? That's the circumstantial evidence. It's the wet coat, the umbrella, and the wet shoes. So like in a closing for a criminal case, if there's no direct evidence, meaning no eyewitness, no DNA, the victim is gone, you know, it's a murder or something, then you have no direct evidence. And so from a defense standpoint, you're defending this case and you know that the state has to prove beyond a reasonable doubt that your person did it. You're pointing directly to the fact that they have no direct evidence that your client did anything wrong, period. Their whole entire case is circumstantial. On the flip side, you know, the state has to be aware and explain to the jury that the burden of proof, the beyond a reasonable doubt, isn't all doubt. It's doubt that's reasonable, right? You'd probably explain to them some examples of why those doubts that are reasonable should be resolved in your favor. And then on your summation, let's say there's conflicting testimony. Well, again, you would spin that conflicting testimony in your favor by obviously pointing out the things that are consistent with your theory of the case. When I said the judge is going to read you the jury instructions, again, it depends on the case, but generally my experience has been they do it after your closing. So you think about delivering an amazing close, and you're like, yes, and then you sit there for an hour and 45 minutes while a judge reads a book, and then you feel like you've lost all momentum, right? But that's just the way it is. So what you're also probably going to touch on in your close is telling them what you're getting ready to hear. Hey, judge is getting ready to read you a bunch of instructions. Let's talk about some of the ones that are important for your case today. Assault, and I don't know what those elements are, frankly, but you name the elements. This is what assault is. This is why, as the state, we've proven it. Or conversely, as a defense, they have not proven assault because they've missed these two elements. And the judge is going to tell you what, how to resolve conflicts when you have conflicting eyewitnesses. That's what the rule is. Let me tell you how you're going to resolve those conflicts. So you're going to use those, the rules, the jury instructions, and the elements. You're going to use those in your close because they're getting ready to hear them. So you might as well tell them what they mean before the judge instructs them and they fall asleep. So hopefully when they hear that assault means blah, 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 they're going to say, oh yeah, I remember him saying that. Okay. I mean, it's really boring stuff when they start reading these instructions. The other thing that you can do in your close that you can't always get away with in opening is using stories, plot lines, things that people relate to. And I'll tell you one I did one time. It was a weird case where these people bought a house. It's like a $500,000 house on the lake, or it's a condo on the lake, and it was made of stucco, which is, if y'all aren't familiar with stucco, it's like a cementitious type of material. It's often used in Arizona and New Mexico because it's meant to be in dry conditions, but they brought it out here to Knoxville for a period of time, and it has never worked. I've learned more about stucco than I ever needed to. But basically, I represented a home inspector. He did a full home inspection, and he noted some areas where the stucco was moist, but you know, home inspectors are pretty limited in what their job is, and that is to basically point out anything of concern. So ultimately, it turns out that the whole stucco was rotted, and they sued all kinds of people, including my guy. And so I stood up and I said, ladies and gentlemen, when my brother turned 16 years old, I sold him my 2008 Acura TL. It was silver, black leather interior. It was his first car he ever had, and I sold it to him for $2,000. And he was so excited because he loved that car when I had it, and now it was his car to drive, and it was a great deal. And it had a Bose stereo, and it just looked sharp, and it was a super exciting moment for both of us. And 2 days later, he was driving down Kingston Pike and the transmission went out. And I felt awful, terrible about it. And I was, obviously I gave him the money back, and I was like, brother, I'm so sorry. I had no idea. And he said, Adam, sometimes bad things happen and it's nobody's fault. And that's what happened here. It's awful. Their house is destroyed, but it's not my guy's fault. He did what he was supposed to do. Bad things happen. It doesn't mean it's somebody's fault, right? So I used that story to then try to tie in my theory of the case. If you were to try to do that in opening, you might get dinged by the judge, because the judge is going to say, what are we looking at here, counsel? What's the facts? Let's move on, because that's how they are. Judges are very impatient from time to time. So in closing, you're going to get a lot more leeway to use narrative stories. We've all heard of David and Goliath. You've heard of, good versus evil. That's where you can really emphasize those things with a good story, plot, motive, battle, something like that. It's a much more liberal time because, again, your opening is really kind of limited to, this is what the proof's going to show. This is the outline of the proof. This is who's going to be here. This is why we think we're going to win. And the closing is, let me tell you all the stuff that we did to win our case and give you some reasons and theories and themes that you can tie into, that when you go back in that room, you can be like, man, I mean, I kind of agree that, sometimes bad things do happen. I mean, doesn't mean it's anybody's fault, right? So you're kind of giving them something to tie in to the, hopefully, outcome that you want. So you're going to start with generally your theory, go into some type of story that ties it together. You're going to go into, what did we have to prove? What evidence have they tried? What's their theory and theme? And why is that just not correct? Why if there's any conflicting evidence, it needs to be resolved in your favor. What's the law say? And why have I met what the law says? Or why have they not met what the law says if it's their burden? Meaning you're on the defense. Why have they not met their burden? Why have they not met that high standard of beyond a reasonable doubt? Going back to your theory, going to your verdict, because what is the ultimate goal, right? In your close, you got to tell them what you want. I want you to find in favor of my client. And when you get back there, you're going to have a jury verdict form. We expect you to check this box because you're going to do what's right. You're going to use your common sense, and we've met our burden, or they haven't met their burden. So that's the overview of a summation. All right. I mean, you can break it down into those categories to keep yourself on track. And again, remembering that you're probably not going to win the case. You're not going to have a full panel of unbiased, on the fence people by this point. But hopefully you're going to have some people that are already on your side, and you can give them the fodder to help convince the other people, or to the extent there are a couple people that are kind of going back and forth, you're giving them those nuggets that are concrete, anchored terms and phrases and theories that they can say, I get it. I mean, I believe them, right? Another little point that's not really in this context of the structure, but you'll know if you can read people at all. You'll know if they're thinking the way you're thinking. I mean, you're gonna. I've looked at jurors and they're just like, and it is not fun. That that they just think you're baloney, and you got to figure out a way to get that person at least somewhat not hating your position. But on the other side, when you're looking at that person and you're like, yes, got them, right? That's a good feeling. And then you'll get the random person that is literally, you're like, are they even here? What are they doing? You're like, they're just not even like paying attention. They're just over here and looking down. And it's a lot of that reading the room kind of feeling. Another kind of thing, you're generally not objecting, so you can, I mean, you're allowed to, but it needs to be really extreme. So don't kind of get into that thought of like, if they start talking, you're going to object. It needs to be something really extreme. For example, the DUI thing, right? It's something that wasn't even in evidence. It's super prejudicial. The judge excluded it and they're bringing it up. That would be an appropriate time. If it's, them calling your client a liar, you ain't going there, right? I mean, if you want to call somebody a liar, go for it. I don't think that's the best way to do it. I think I like to use the term, whether they don't remember it correctly, or whether they just don't have an accurate memory of the events. You kind of say those kind of things. The jury gets what you're saying. They're a liar, but they, That's not my style. I guess I should have said this from the outset. The number one thing for litigation in general, outside of closing openings, you got to be yourself. You can't replicate someone else's style as effectively as you can be yourself. And ultimately, if the jury believes that you're genuine and credible, you're going to get further than if you're trying to be some guy you've seen do it. All right. That doesn't mean that you don't take things that you've seen that you've thought were done well. But to give you a great example, there's a lawyer here in town. His name's Tom Johnson, and he's probably 70-ish, and he's bald, and he looks exactly like a grandfather that, you know, you just picture in your mind. All right. And Tom Johnson, when I worked for him, every time I'd go into his office, I had thoughts on the case and why what I thought the case was going to go, or what I thought to be really bad evidence, usually, right? Like, hey, we got a problem, Tom. Every time I leave his office, I was convinced we were still right. And he had an incredible ability to he would literally do stuff like this. He would be like, so let's say a witness says something that's just a lie, or that just doesn't make sense. He would just scratch his head, and he kind of wrinkle his eyes, and he kind of look, and everybody knew what he's thinking. Like, you believe in what this person's saying? But he didn't. I could never do that. I mean, it would be so fake for me, but right. But I mean, I would love to, but I can't. But that's my point. It's like, you're going to find things that are just super effective, and to the extent that you can adopt them to your own style, that's way better than trying to be that person that's really good at it. If you're really into this stuff and you're really a nut, there are great blogs or podcasts on these litigation. One guy, well, if you're into the plaintiff side, his name is Mitnick, M-I-T, I think N-I-K or something. But there's guys that do this way better than I do, right? And they've been doing it for a long time, and they try a lot of cases. The problem today is not a lot of cases go to trial, so there's just not a lot of experience. And your best way to get better is to keep doing it.
Hey, Adam, we have a hand raised right now. It's
love it. High five.
The Honorable Bree Wiener is asking a question.
Hey, Adam. I had a question. In Tennessee, do you get your juror list prior to trial? In Virginia, we get it here. So I was wondering if you guys in Tennessee, if that's allowed, how many days, and do you do any sort of jury research based on?
I think I lost you there at the end, but I think I know where you're going. The answer is yes.
That entire time.
Yeah, I heard you, I think. Yeah, so what, in state court, okay, Knox County, if you're in Knox County Circuit Court, right there downtown on Main Street, the ugly spam can looking thing, you're getting jurors in Knox County. It's people that are registered to vote. So they have a panel. I can't tell you exactly, but they usually pick a jury panel about every other month. And so those people are on the panel the whole time. And so it depends. The answer is yes, but it also depends on when your case is set. So let's say, for example, the panel starts on April 1 and you've got a trial on April 2. So you may not get that information till like today, March 22nd, but the person that has a trial on April 15th, they'll have 3 weeks to look at that. What's more crazy is the first jury trial I ever tried, I get up to, I'm super nervous. stand up. I've memorized a little opening on voir dire to talk about, hey, this isn't what you see on Law and Order. This is nothing you see on Boston Legal. And they're like, oh, I know, we just did this like 3 days ago. And I'm like, oh my gosh, you all have just tried a case? I haven't even tried a case. And so it's crazy because you'll sometimes get jurors that like are on multiple trials, multiple, you know, in a 2-week span. But to your point, Bree, when I worked at the big firms, right, when you had the machine, it was like all hands on deck, Facebook, social media, LinkedIn. Who are their wives? Who are their wives' friends? Who are their husbands? Where do they work? What are they? I mean, it was crazy. And we would develop, I wonder if I've got one. We would develop basically a master cheat sheet of all these people. And it was so weird because when they would, so what happens is the jury room is, it maybe has like 65 people. And let's say it never happens anymore, but let's say you had 2 trials. So you'd split that into 30, but let's say for the purposes of this, there's 40. They're all sitting in the courtroom, all of them. And the judge literally like goes, Wes Ecke, number 1. And you see Wes stand up and he walks over and he gets in the box and he pulls out there, Celia, number 2. She gets up, they're kind of looking at each other like, hey, how are you? And you're sitting there thinking, oh my God, Celia's husband worked for blah, blah, blah. And you like already know these people. And so, yes, but the hard part is, well, let me put it this way. They know that what they're putting on their sheet is going to be known by the lawyers. So it is appropriate to be like, Ms. Ball, I see here that you work at McDonald's, because they know that. You don't talk about the fact that you know all the other stuff, right? So you try to elicit that. But yes, 100%. And that's why you really, if you're really doing it, you want to have your paralegal or another lawyer or somebody taking down all this information and really kind of being the sounding board that's kind of, because you're trying to engage them. You know, last thing you want to do is when you ask them a question, you're looking down and writing stuff. You want to be like super engaging and super conversational. So you're hoping your assistant back here is making all these notes, because to the end game, you get to strike 3. And so you can have, and in Tennessee, you can have back strikes if a judge will let you.
And those strikes might not necessarily be something that comes out in voir dire, but something that you know just from doing your research ahead of time.
100%. Yeah. I mean, generally speaking, most lawyers don't want engineers on the jury. I was on a jury one time. They did not want me. They don't want, you got a med mal case, you ain't putting a doctor on there. You got an employment discrimination case, you ain't putting an HR rep on there. I mean, you already know. I mean, you can almost, what's the craziest? I'll tell you, if I need to stop, I'll stop. I got a jury panel one time and it was my friend that was on there. And I called the other lawyer and I said, hey, I know this guy. And I just wanted you to know before we even get in there, so it's not even an issue. And I said, we're not best friends. I don't have a cell phone number, but I mean, we grew up together. I mean, we played golf together. I've known him. I know him. She left him on there. And so when he got called and he goes up there, the judge is going to do some general stuff like, does anybody know the lawyers? Do they know the law firms? Yes, I know Adam. Yep, we grew up together, went to school, and I'm sitting there thinking he's out, right? And they left him on there, which was the greatest thing ever, because when the trial was over, he told me everything that happened back there, which you never get to find out about, which was incredible. He told me the first thing he said to me, I said, as soon as the trial was over, I said, meet me at the bistro. I need you to tell me everything while it's fresh. And he met me down there. And the first thing he said to me, he goes, I will never go to trial. That was the most miserable experience. These people are crazy back there. So, but to your point, yes, you're 100% getting the information on all the jurors and all their background. A great voir dire question that you got to be careful, but If you ask people what kind of bumper stickers they have, you're going to find out a lot of information. Because people have some really interesting bumper stickers. But back to the summation here. Does anybody else, I don't know if I've done what I needed to do, but
I guess one of the
give me
big
some thoughts, Wes. Yeah, what do you need to do?
one of the big questions that we had last time we did this was structure. How should we structure a closing argument? So I guess if you could talk on that, that'll help out a lot of the people.
Yeah, sure. So for you all that are doing this thing on Thursday, I think your general structure would be theme or theory of your case. This case is about, at the beginning of this trial, we told you about this. This case is about whatever you want to make it. Or do your story, biblical theme, book, Socrates, whatever, right? Something that's basically you've got, I can't remember exactly, but you've got about less than a minute of an attention span these days. I mean, I think it's down to 20 seconds. It's like a TikTok attention span. So you don't have a lot of time before you lose these people. So the first thing you stand up is, ladies and gentlemen, really appreciate you being here today. You play a really important role. They're like, are you kidding me? I did not choose to be here. Thank you. You lost them. So it needs to be pretty quick. Your first thing out your mouth needs to either be a really compelling story or, right to your theme. And then again, your structure would probably be, and again, and I should have said this earlier, your summation isn't just a summary of everything you just heard. Again, that's super boring too. I mean, they're like, I know, we heard all of this too. So you come out the gate with your memorable story, your theme, your catching thing, your theory of the case, and then you're probably going to go into, let's talk about why we have proven our case or why they have not proven their case. And then you're going to highlight the good facts by way of testimony specifically. So you're not going to say, you heard that he didn't run the red light. You're going to say, Miss Jones got up here on the stand and she told you that she was there, that she was at the scene. She's not related to any of these people, that she was just sitting there at that red light and she saw the defendant run the red light, right? So you're giving them really specifics of the testimony. And then you're going to talk about, again, that would be testimony or exhibits. If you are the defense, that would be the next step would be to rebut the plaintiff. And if you're the plaintiff, you should know by now where they're going. So you can kind of anticipate or head them off at the pass. So in other words, this case is about crappy cars that break down. Let me tell you why we're going to win this case, what we've proven to you today, why I know that you're going to find for us this evidence is really good. Or anticipate that they're going to get up here and they're going to tell you the car was just fine. Well, let's talk about that for a second, right? So you're going to rebut some of their evidence. And then I typically would go into the whatever you have to prove, right? So whatever if it's an assault case or whatever, I would specifically talk about those elements and go by one. What are these elements? What have we proven? I always like the jury verdict form. And then you're going to end with your ask, right? Your last thing needs to be, find for us, do what's right, do what your common sense tells you to do. Does that make sense, Wes? You got anything to add? I mean, y'all, you've done it a bunch. I mean, bottom line is for you folks that are kind of 1Ls, 2Ls, you're probably going to try more cases in a mock trial scenario than you will in the real world, at least for your first, unless you're doing court-appointed work, frankly. You're not going to try cases. Maybe one or two. So that's why mock trial is so important, is because you're going to do this multiple times, not only on one fact pattern, but hopefully multiple fact patterns, and you're going to develop your own kind of style that works.
Adam, so if things are going to be the same as they were last year's tryouts, for the people that are trying out this year, obviously we're not doing a full trial. So just like Adam was telling you guys how you're going to be filling in your clothes with actual testimony that was said during the trial, you know, for this competition, obviously we're not going to have that stuff. So, I mean, Wesley, unless you advise otherwise, I mean, I would say to be creative, guys. Like if without the testimony, it's pretty much just a story that you're telling and your side of your story. So I would say get creative. You could make up your own testimony, obviously it being realistic or something. You know, you just heard the defense's star witness tell you blah, 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 blah.
He wasn't looking. He was not looking. Yeah.
Yeah. So the fact pattern, I don't think has been released yet. But, you know, be creative with it. And also, I'm not sure if it will be the same as last year for closing arguments as it was. So last year we had to do opening statements. And then for the close, I think we had to do the other side. I could be wrong about that. But, you know, if that is how it will still be, you know, be creative with it. If you just said the theory of the case is, you know, follow the rules and no one gets hurt. Now we're on the other side and we're going to do a close. Try using that other team's, or well, yourself, but your opposing counsel's theme, and try to work it into your close, even though you came up with the themes for both. Does that kind of make sense?
So wait, let me make sure I understand. So what's happening Thursday is the summation of something they've already opened on?
I was talking about the actual trial.
Okay, yeah. So for Thursday, you're giving them just like a brief fact. You're not giving them depositions or testimony.
Nah,
You're just giving the facts of what happened.
Yeah, I'm basically giving them facts of some, you know, stuff in there that could, I guess, swing the evidence one way or another. There's just certain little things. I'll send it to you when I add some more. I'm gonna, you know, re-release it tonight. Oh, yeah, tonight.
Are you gonna at least say like people's names?
Yeah, I'm gonna add people's names to it. Last time I just kind of left it really generic.
Yeah. So for you all's purposes for Thursday, I would say, if Wesley says, you know, the defendants is John Smith and his witness is Kevin Johnson, and they were at a party and John Smith punched somebody, but it was in self-defense, then you would basically say, you know, you heard John Smith get up here and he told you about the punch. Why did he punch him? Well, he told you it was in self-defense. In defense of what? He told you that Daniel, the victim, tried to punch him, right? So you're kind of filling in that gap with details that are probably not going to be in this factual pattern. In the mock trial context, you're going to have the testimony of the witnesses. So you're going to know what they're going to say. So then you're going to be using actual testimony. In this instance, it would be appropriate for you to fill in specifically what you think their testimony would be to support your side. And that would be appropriate for you to, I mean, you're kind of making stuff up, but you're making it up in the context of these general facts. Here's a good, let me, if you'll give me a minute. I pulled up a really good close that somebody did.
I was just about to ask that if we can get an example of a close to show people. I mean, we don't have a whole lot of time left. I don't want to keep everybody for, you know.
Yeah. I got you. This is a case where these electrical power lines malfunctioned, and broke and basically electrocuted a boy. All right, so this is the close of the plaintiff. So you're going to imagine they're going to have all the evidence, and they've already heard everything. They've heard the testimony. So here's what he said. May it please the court. Now you're going to hear that. You may hear the people say, may it please the court. That's a formal thing, and that's an appropriate thing to say, frankly. In federal court, you should always say it. Federal court is a very formal environment. So it would be appropriate to say, may it please the court. And that is basically you saying, what I say should be pleasing to the court. And it's just formality. But it's also a way to kind of get that first second out of your mouth where you're not just bumbling into the story. May it please the court. I've asked my client to leave the courtroom, as I asked him not to be here during the medical testimony. We listened to the doctors explaining what a dismal future he has. He's going to be in a wheelchair, unable to walk more than a few steps because of his paralysis. A boy with no arms, grotesque mechanical claws. Think about that. Grotesque, right? That's an anchored word. Grotesque mechanical claws for the rest of his life. That is a fact, and we have to accept it and base our decisions on it. Ben, so this guy's using his first name. He's not calling him the plaintiff or my client. He's saying Ben. Ben is only 14 years old, and he still has hope. The dream of a doctor inventing a bionicle arm that'll look natural. The dream of being able to run. I did not want to be responsible for shattering that dream by making him sit here today and listen to the brutal facts. He has been sentenced to a life sentence in a wheelchair for something he did not do. I mean, that's powerful stuff right there, right? There's been a lot of medical and other testimony, and we want you to thank you for being attentive. We have the burden. It's a grave one. Oh, sorry. The burden is on you, and it's a grave one, to arrive at a fair and just verdict. I'll take a few minutes now to review the case as we see it. There's three main points to this lawsuit. First, we're not dealing with an ordinary product. We're dealing with an electrical power line. They carry electricity, silent and invisible, but it can blow your arms off. That's powerful words right there, right, guys? But silent and invisible, and it blows your arms off. You could never say that in an opening, and it can kill you in a split second. Electricity is dangerous, ultra hazardous, and the defendant electric company should have taken precautions to prevent this deadly, dangerous event from causing harm. They did not, so you should hold them responsible. Second, we're not dealing with an adult. We're dealing with a boy who was 12 when he was crippled. Again, crippled versus injured, right? Crippled without any warning. He did not have the experience to know that this small black wire was dangerous, so he did not know that playing with it was going to hurt him. The third factor, his injuries are permanent. He's been given a life sentence without the possibility of parole or the time off for good behavior, for which you should award him enough money to last him for his lifetime. How do these factors fit together? As we look at the overall lawsuit, what are the issues? Basically, we're talking about two things. Is the company liable for his injuries? If so, how much money are they worth? Well, let's talk about whether they're liable. This boils down to two questions. Was it foreseeable and was it preventable? The judge is going to read you the instructions on the law, and then he reads the instruction, right? There's no question about the first element. So now this guy's hit the elements, he's hit the instructions, and he's telling them what they've got to prove. And now he's saying there's no question about the first element. You saw the photographs of the utility pole. So he uses the written, he uses photos. Witnesses pointed out that the uninsulated high voltage line that fell and the guy wire, whatever, showing another picture. And you can clearly see for yourselves that there is no insulator on the guy wire, no warning size. That's not in dispute. The dispute centers on the second and third elements. Should they have known that children were likely to get near the pole, and could they have eliminated this danger? In other words, was it foreseeable that a 12-year-old like Ben would be tempted to climb over to the utility pole, and the law requires the company to prevent it and protect him from harm? How do we know it's foreseeable to children? Well, you can look at the common experiences of all of us when we were young. We probably climbed poles at one time or one another. You can look at the testimony, and then he talks about testimony. He admitted on cross-examination that he had even climbed a pole as a child. But what is the best evidence for whether the electric company should have foreseen that the children would climb poles? It's the National Electric Safety Code, which was introduced into evidence. And then he goes through that. Could it have been prevented? We're not talking about expensive. We're not talking about expensive fences, folks. The law only requires that they take measures that are easy and inexpensive. You heard testimony it would cost $3 to prevent this injury. Right? Those are powerful things. So then he says, and then in this juncture, he deals with what they call contributory negligence. Why wasn't the boy at fault for doing this? So he says, now in some cases, you're going to have a defense. So this is where I'm talking about rebutting their case, right? They're going to probably say Ben's at fault. Well, the judge will tell you, if Ben's at fault, that's it. If he knew or should have known and ignored it, then he shares responsibility. But that's not a real defense because there's no evidence to support it. How could he have known that it was dangerous if they didn't have any signs warning him? Right? So now he's rebutting their side. And then he goes on to damages. The second thing you got to determine is damages. This is important in terms of Ben's future. The judge will instruct you that if you find for the plaintiff, it's your duty to decide what sum is going to compensate him for his injuries, his paralysis, his life sentence in the wheelchair. There is no way to measure that. All right, then he goes through that. One last thing you're going to hear sometimes from the plaintiff side. Do you suggest a number? I think you should, right? Because you're asking them for a verdict. You might as well ask them for the amount you think it's worth, but you better give them a reason. And so what you typically would have is you'd have somebody come in there, what's called a life care expert, and they're going to say it's going to cost X amount of dollars to care for this paralyzed child, for his medication, for his wheelchairs, for making his home wheelchair ramp, a new shower, blah, blah, blah. That's X amount of dollars. So you give them a reason for that number, but you definitely want to give them a number. And that's kind of the hardest part, right? Because you're like, man, how do I ask for $9 million? Well, you got to tell them why. Why is it worth $9 million? So anyway, that's an overview of summation. Any other questions? I don't know if we're done at 5:30, but if there's any other questions, comments, I'm happy to talk with y'all about it.
I kind of think it's important to note, like when we're doing trials, we will make notes throughout the trial, important points that were made on, a cross-examination, like, oh, well, they said this, and adding that in where a closing is not something that we ever prepare like verbatim beforehand.
Yeah, and I think for Thursday, you need to give it good thought as to if this was a real trial, what would these witnesses really say to support the general fact pattern in this case? So if Wes is, what is it, Wes? What's the crime?
Murder, first degree murder.
Is there somebody that saw it?
There's someone that saw her leaving the crime scene at a high rate of speed, someone who I think heard the gunshots, and saw the daughter saw her mother rummaging through a closet where she knows a gun is kept.
Yeah, so then you all would fill in those gaps. So-and-so told you that they saw this vehicle and it was going quick, and so told you that they were looking through. So that's not going to be what Wes sends you. It's not going to say what they said, but you're going to have to use your inferences to say, well, how did that fact get there? Well, somebody must have said that, right? So you're going to use that fact to determine the testimony that you're going to close with. But listen, I mean, this is tough stuff. I commend you all for doing this. You can't go wrong, because ultimately the day you go to court, and most people will go to court, you don't want it to be the first time you've tried this out. So this is the venue in which you need to sharpen your tools, because for all intents and purposes, it doesn't matter. Okay. I mean, you're not really sitting there with a client that's going to be pissed if you lose. So you need to, the more you can do this stuff, the better you're going to be when you get out there, and you can at least say, I've done it, because the framework in which you're doing it is very similar, but what's on the line is a lot bigger. And so if I had it my way, I'd want everybody in law school to do this stuff. And I commend you all for trying it. About a year. She asked, how quickly did I have my first trial? So I got lucky, because lucky or unlucky, I got kind of in a work comp. Workers' compensation means you get hurt at work. So I got thrown into that area of practice of the firm I was in. And the good thing about work comp was there's a law that basically says this is the range in which the value. So work comp isn't usually did they get hurt, it's just how much. So when I went in there on my first trial, actually it's really embarrassing. I'll say my first real trial. That was my first actual trial was in general sessions, which is small claims court, which is like Judge Judy. They don't do a lot of openings and closings. They want to get you through there. But my first real trial, when you do insurance defense work, or you work for a company that's getting sued, they typically want to know, what range are we looking at? Like, where are we at, right? And the range here was $50,000 to $275,000. And my first trial, I lost $275,000. And I'll never forget, it was Cinco de Mayo, and I just went straight to a Mexican restaurant and called my grandmother, because it was her birthday. And I said, I don't know that I'm made for this stuff. And as it turns out, everyone at the firm knew this was going to happen, and that's why they sent me. But there was a silver lining, and that is we appealed and we got it knocked down to 50. So that worked out good. But depends on where you go, right? If you're going into the firm environment, you're probably not going to be trying much for a while. If you go into a smaller practice, you may well be in there. I mean, I argued my first motion. Again, I mean, you're still in court, you're still in front of a judge, you're still thinking on your feet, all skills that you're getting in mock trial, because you're in these mock trials, you're going to be trying them to judges and to lawyers. So when you go in there for an argument, I mean, my first argument, the judge, I hadn't been sworn in by the Supreme Court yet. So I had to go into chambers and get the judge to swear me in, and then walk out there and act like I was going to win this motion, which did not happen. In fact, it was really embarrassing, because I prepared like it was freaking Supreme Court, and I had a notebook, and I mean, I thought I was really, really good. And the other lawyer, he'd been doing it about 50 years. And so I do this argument. I mean, I'm going through case law and just, really gave it everything I had. And the other lawyer stands up and he said, Judge, I just rely on what I wrote in my brief, and just sat down. I was like, what? You can just do that? And I lost. So there's a lot of real world stories I can tell you about that would make you feel probably better. If something happens to you, it's probably happened to most of us.
Thank you, Adam. Thank you so much for coming and talking to us about this, giving us your real world experience and the things that you've seen and gone through. It's great. You know, everybody
Yeah, man.
has a story of where, you know, they didn't do so well, went to a Mexican restaurant to drink. Everybody has that.
Yeah, never forget it, man. It was just one of those kind of things where you're thinking that's as bad as it could get. Like, how did that happen? I thought at least it'd be like something a little less than the worst.
Yeah. But nah, it's, you know, it's a good story to hear because again, we're all going to find ourselves, you know, in a situation like that. And it's just a matter of how you pick yourself back up and, you know, deal with it, keep on going.
Yeah.
So,
Hey, listen, there was 140 lawyers in that firm, and I had the worst verdict of any of them for that year. And I still worked there the next year.
Yeah. We're all, you know, we're all learning this at the same, you know, we're all going to be at some level, you know, right there.
Well, you've probably all heard this. It's called the practice of law for a reason. It's not a corny saying. And I'm gonna get on my horse here for a second. The biggest issue, and I've told my folks this, but everybody needs to hear it. The biggest issue with lawyers that come out of law school is they feel like they've got to prove themselves, and they've got to, you know, they're young and they're inexperienced, and so they've got to be either aggressive or know it all or whatever. That is the wrong way to come out the gate, and it will impact you negatively for a long time because it's a small bar in Knoxville and it's a lot smaller in smaller counties. And if you come out the gate, I will say this, I promise you, you're going to probably at least feel like you've committed malpractice every day. And if you don't acknowledge that and seek help from other lawyers, it's not going to work out. It just won't. And it's true. And so, I mean, I'm convicted in that regard because I want you all to succeed. And it's a humility aspect that is lacking sometimes. And I've told my folks this again, but if you treat it as this person on the other side, 99% of them are not your enemy. They may be in that moment, right? In that moment in court, they may be your enemy. You certainly don't want your client to think you're buddy with them. So, I mean, there is a certain decorum that you have to present, but 99% of the lawyers on their side want to help you. But they will not want to help you if the first thing out of the gate is you're wrong, because they're probably not wrong, all right? Even if they're wrong, they're probably not wrong. And that's just true. And so what happens is if you come out with the humility and the understanding that you don't know anything, you're going to find that the lawyers on the other side might really help you. And that is really how you're going to get better at what you do, because they're going to realize that you're just somebody trying to get better and they're going to want to help you. Most people want to help. They don't want to just beat you down, at least here, at least in Knox County. I mean, our bar is so cordial. The Bradley County bar, Monroe County bar, Nashville is a little more intense. Chattanooga is not real friendly. But here you are going to be successful if you will just be humble and try to do your best and acknowledge when you don't and seek help when you need it, which is going to be often.
All right. So note to self, impending doom. The feeling of impending doom is normal. And
yes,
knives are out in Chattanooga. Great.
Don't go to Chattanooga bar. Yeah, it's not fun. But here it is. And, you know, you're going to be needing help. And so if you're not giving it, and when I mean help, like, let's say somebody's late on a deadline and they call you and they say, I need help and I need an extension, and you say no, you got 25, 30 years of getting no's from that same question that you're going to need to ask a bunch, right? And I tell my clients, I literally tell them this. I say, I know your case is important. It is super important to me. It's probably the most important thing to you, but your case is not going to ruin my reputation in this bar. And I'm not going to, because your case is going to be over and I'm going to still be practicing. And so I cannot allow your position to ruin, I mean, to a certain extent, right? I mean, we're not talking about like giving them all the evidence. I'm talking about just being cordial, you know, the weather, you know, you're going to find clients that want you to be a certain way, and you cannot let your client control your practice. They hired you, all right? So why'd they hire you? For your advice. If they're not going to listen to you, go find another lawyer. Don't let it ruin your career. I mean, that's very important to me. So you all, to the extent I ever meet you again, you're going to hear that from me again. But thank you all for being here. Thanks for caring about this stuff.
Of course.
Adam, you're awesome as always. For the people that are trying out, you know, I'm not sure how Wesley has the schedule for this coming time, but last year the callback essentially was our closing arguments, and I believe we only had like one day in between. Now, as Adam told you, you're going to be pretty much filling in your closing arguments with things that maybe you just heard that witness say 15 minutes ago. So it's something to be quick on your toes. But for this tryout, you know, you might not give a closing argument if you're not called back, which is fine. You know, go to that Mexican restaurant. But while you're making your opening, in terms of time management, I'd highly recommend you just go ahead and make your closing, and kind of use your opening to formulate your closing, and vice versa. Because, you know, if you're having one theme of the case, you need to be continuing that theme in the closing. Or like I said earlier, if you're doing the opposing side for your closing, be using your theme from the opening to then turn it on its head. But just in terms of time management, just go ahead and do both.
Awesome. Well, again, thank you everyone for coming. Thank Coach Adam for coming and helping us out. I will tweak the fact pattern and I will release it tonight. Yeah, we do need a good list of Mexican restaurants. But yeah, so I'll tweak.
There's plenty of them.
Yeah, especially around here. And then I will release it and you guys can get to work. So again,
yeah, if I can be there Thursday, I will.
Awesome. Cool. Thank you so much.
All right. Thanks, guys.
I will see you guys Thursday.